Yes, please start the program. Already we are running
Yes,
late.
sir. Yes, sir. Good afternoon, sir.
Very good afternoon.
Myself, Dr. S. Venkateswara Rao, Professor and HOD, Department of Pharmaceutics, Vijay Institute of Pharmaceutical Sciences for Women. It's give me immense pleasure to welcome today's research person, Dr. Bharat N. Suryavanshi, Assistant Controller of Patent and Design Filing, NIPAM, Nagapur, and respected Principal Madam, Vijay Institute of Pharmaceutical Sciences for Women, and all the faculty members and students participants to this today's webinar on intellectual property rights. Intellectual property rights, patent and design filing, organized by Vijay Institute of Pharmaceutical Sciences for Women, NK Padu, Vijayawada, in collaboration with RG Nipam, Nagapur. So, in today's innovation, okay, sir. Okay, sir. So today's we have resource person Dr. Bharat N. Suryavanshi as the resource person to organize this webinar. Good afternoon, sir. So now I request Prasanna Madam to introduce our resource person.
Good morning, all. I'm very delighted to introduce the profile of our today's speaker. Dr. N. Bharat Suryavanshi Garu is working for more than 20 years in Central Government Office under the Patent Office, Ministry of Commerce and Industry, and presently working as Assistant Controller of Patent and Design. He has done PhD on the topic bioefficacy and phytochemical studies on medicinal plants of Kinvat and Mahur forest of Nanded district from Swami Ramanand Tirth Marathwada University, Nanded, Maharashtra. He has done MPhil on topic plasmid profile of proteolytic lactic acid bacteria from Gulbarga University, Karnataka. Postgraduate in biotechnology from Gulbarga University, Karnataka. Secondary education at Jawahar Navodaya Vidyalaya, Bidar, Karnataka. He has published various national and international papers. He has successfully examined and disposed of numerous patent applications over the course of his tenure. He has delivered many lectures on IPR in various parts of our country. He has reputed for training at Tokyo, Japan on examination and IPR issues. He has been a part of various judicial, national, and international training programs regarding IPR practices. He has given landmark decision by rejecting Pfizer patent application for arthritis drug, which has filed in India. With this brief note, I would humbly invite the eminent personality in the field of IPR, Dr. Bharat and Suryavanshi, to drive us into the session. Welcome, sir. The session is handed over to you.
Thank you, ma'am. Thank you so much. I also welcome you all for the IPR session on behalf of Rajiv Gandhi, National Institute of Intellectual Property, Nagpur. Please allow me to share the screen. Stop your screen. So you know what is intellectual property. Now let us see how to convert your idea or research into inventions also. As you are belongs to nice city, I had been to Vijayawada also many times for physical lecture, even for the Guntur also many times to pharmacy college. Very nice place. So yes, so I'll share my slides.
Yes, sir.
Okay. Are you able to see my slide now?
Yes, sir. Yes, sir. Visible, sir.
Yeah, we can see today's topic, what is intellectual property? Now I have taken first slide to make you understand this one. Why? Because any idea that arises from your mind is called intellectual property. Therefore, I'm showing blooming of the light. It means all the ideas coming from your mind, lightning from your mind. Therefore, simply I can say any idea that arises from your mind is called intellectual property. For example, we know at present for the cancer, we are having allopathy and chemotherapy. There are two treatments, but how much side effects are there? By keeping all the side effects in my mind, I am botany fellow, I'm developing herbal composition for treatment of cancer. What is this new idea? New formulation for treatment of cancer. Again, you can go for the patent. Please don't talk. Many are talking. You are the co-host. You are the host. You can mute them. Those who are not interested, they can leave. The persons who are listening, let them listen. Please mute them. Prasanna, please mute. Any work, talk after that. I'll take another example to make you understand. You know, in December 2019, we heard about the coronavirus. At that time, we are not doing what is coronavirus. What's its molecular structure? Therefore, in the middle of 2020, we got many scientists thought and we got Covaxin, Covishield, Sputnik. What is that? Problem came, scientists thought, did the research, and they given solution to technical problem. As in vaccine composition. Again, new idea, new technology to solve the problem. If you're developing new design for the RT-PCR, the idea to develop new design is again arising from your mind. Therefore, it's an intellectual property. You can go for the design. Somebody is writing new book that the medicinal plants in the Vijayawada area. So idea to write the book is arising from your mind. So you're writing the book. Again, it's an intellectual property. So simply I can say any idea that arises from your mind is called intellectual property. So let us see how this property arises. When you are in the classroom with your student, or you are in the laboratory doing the research, or sitting alone or in a group of people and discussing on a particular topic. For example, today we are sitting in the lab, we are discussing petrol diesel is there, but what about the next generation? It's not a renewable source of energy. So somebody among you get the idea, sir, we can produce biodiesel. What is this? New idea. How idea came? From your mind, you are thinking, are you developing? That's again intellectual property, giving solution to technical problem. I quote another example. There are many blind people in the world. They are walking by using the stick. So this is a problem I am solving by giving a smart shoes for that. What is this? Solution technique problem. Up to 4 meters away, they can walk easily on the road and they can get the solution to technical problem. Again, new invention or technology. You can check in the Telugu what we call for this mova flowers. Mova flowers. Botanical name is Maduka longifolia. These flowers were known for only production of the liquor. But Dr. P.C. from Balpande College of Pharmacy, Nagpur has developed cold drink formulation as an MOA drink. And the people like the taste of that. What is this new formulation? New technology, innovative idea, innovative formulation. Again, you can go for the patent. Again, we have got many inventions in this, like healthcare in biotechnology, fintech and digital payment, even smart agriculture product also we're getting, which are IoT based. These are the examples of inventions, or we can say research. These are the simple inventions. Now, let us see what is the background of intellectual property. Property means your mind directly goes to the tangible form of property and you say, I'm having car, gold, plot, flat, even land in my native, so I'm rich enough. But there is another kind of intellectual property which we cannot touch. That is creations of your mind. That's called intellectual property. In that, we are having patents, design, trademark, copyright, and trade secret. Let us see one by one. I told you IP means product of mind, but how to define that? Intangible creations of whom? Human intellect. Human is the intelligent animal in the animal kingdom, having power of thinking, therefore taking lot of challenges. Therefore, we went to Chandrayana. We have invented aeroplane. We have invented vaccines. What not we are doing? So definition is intangible creations of human intellect having commercial value, asset like any other form of property. For example, you are having flat at Vijayawada, you are selling, you are getting the money out of that. Same way, if you are developing biodiesel, herbal medicine for the cancer, any company comes to you, you can take the royalty out of that. Therefore, it's an asset like any other form of property. IP is called as an exclusive right. Somebody is filing patent from your college, the right is with them, not with their parents, children's. Only he or she can exercise the power of that. Therefore, we can say IP is also a negative right. Again, it's an territorial right. Once you are developing herbal medicine, filing India, your right is valid only in the country of India. You cannot claim in USA, Japan, Germany. If you want to claim, there are two ways. One is called PCT, Patent Cooperability. Another is called Convention Application as per Section 135 of the Patent Act. So you can get your right even in the foreign country also. Again, IP is called as an licensable right. If you are having any technology, formula, design, you can give to any company if you are unable to produce it. For example, you are in the laboratory developing herbal composition comprising Regacia tinctoria and Amaryllis campanilis with the other experiment for treatment of psoriasis. There is no herbal medicine for psoriasis. Now you are developing. So you are prepared in the lab, but you cannot produce in large quantity. So you can license to any herbal company and take the license and make the agreement and get the royalty out of that. Because IP is an licensable right. Now, what is patent? Exclusive, monopoly, privilege or rights granted by the government of India to the patentee. Patent means who is applying for the patent. For 20 years from the date of filing, when you are disclosing everything clearly, then only getting that. What is fully, particularly clearly? For example, I am delivering the lecture in Women's College. You are all using different kind of shampoos to take your bath. You are being a pharma students. Why are you using different shampoos? Some heroines are giving advertisement, or you know what is the formulation of that? What is the effect of that? What is the efficacy of that? Or simply are using? We don't know. But if you are developing improved herbal shampoo composition for treatment of dandruff, you can get patent for that. But you have to show good results, more clinical efficacy than the other products. Then no one can stop you from getting the patent for your improved shampoo composition. Again, for that you have to give in detail. That is called fully, particularly, and getting territorial right not valid. If you are filing India, your right is valid only in the country of India. That is patent. Now, B Pharmacy students are doing project, M.Pharm students are doing project, and PhD fellows are doing research for the PhD. While choosing your topic, your professor says, please select 3 topics on your own. Come to us, we will finalize the one. Is this the way to select the topic? No. You should know what is prior public domain problem, how you are able to solve that. Because if you are doing just discovery, we are not giving patent for that. Discovery is not patentable, but inventions are patentable. Then what is discovery? For example, I am a student of microbiology. I am taking my project to isolate microorganism from effluents of Reddy's laboratory of Hyderabad. It's my project topic. So I'm going to Hyderabad, taking the effluent sample from the Reddy's laboratory, bringing sample to my lab, developing improved process of isolation of microorganism by changing pH, temperature, media of isolation for the microorganism. My process is new. I can get patent for that, but not for the microorganism which I have isolated from the effluents. It's just I discovered it, and discovery is not patentable. But if I am using genetic engineering technology, if I'm able to modify that bacteria, then genetically modified microorganism, I can get the patent for that. So, like oil-eating bacteria, heat-resistant bacteria, pH-resistant bacteria, you can get the patent for that. So, discovery is not patentable. Only inventions are patentable. Then what is invention? Invention means new product or process. ATM machine, new product, it was not there earlier. CT scan machine, new product is not there are real. Apple mobile, it was not there in the year 2003. Now we are having. It's a new product. Process of making shampoo. Process of making medicine. So your topic should be product or process. Useful to all. Something novel. And it should not be obvious. Should not be in the public knowledge. Then you can go for the patent filing. If it is the public domain, you cannot. And if uttering section 3, method of treatment, mere arrangement of rearrangement, discovery is not patentable at all. So only inventions are patentable. If a research topic or project topic is qualifying the definition of this invention, then you can go for the patent filing. Granting is with respect to section 3 and 4. Method of treatment, we are not giving patent. Mere admixture, we are not giving patent. Plant as such, we are not giving patent. Animal as such, we are not. Please check the section 3 and 4. It's an awareness program, so I cannot go in detail with that. See, simple example. We take our pet to walk. Our mental is that my house should not get contaminated. My road should not get contaminated, but let the other road. What is it? Why? For this also, solution is there. Invention. Dog waste catcher and holder device. Great technology. Simple, but invention. In India, we are catching fishes by throwing the net in the pond, river, lake, ocean. It's old conventional method. But now, somebody has invented enhanced fish attracted device. New invention, technology. Sharpener was not there when I was student. Now you are enjoying with the sharpener. This was not there. Somebody has invented. Otherwise, Sai Baba movie के दिए लगा के बैठते हम लोग. We would have been put the lamp of the oil only. So ageable. Can anyone tell me this device on the public domain? Even though someone thought to bring the mobile phone, what was necessary? Why they thought? What was necessary? Why they thought? Because we want improvement in technology. This is there, but I cannot change from my cabin to your principal's or cabin because it is connected in my cabin, so everyone has to come to my cabin. Again, if I want to dial 10 times or dial very hectic time consuming. To solve this problem, we got the mobile phone, this landline, cordless phone, many we got. But different mobile, what is this? Ageable to mobile is an improvement of technology. Now we got many things, many improvement also. That's again intellectual properties. See, you can see. So Bluetooth was not there, now we are having. Like AI medical diagnostic devices we got. We can get patent for software, you can get the copyright also on medical device, you can get the patent for that. mRNA vaccines also we got. We can get the protection composition, delivery mechanism, we can get the patent. Process patent also we can get for that. Solar roof tiles, roofs that can function as a solar panel, you can get the patent. And how it looks and function, you can go to the copyright also. Carbon capturing technology, you can get the patent for that. So these are the simple inventions, example for that. So you can see many drones also. Patent is given for the technology, which is product or process, novel, inventive, and capable of industrial application. And it should not attract section 3 and 4 of the patent act. So any technology, if it's new novel, you can get the patent for that. So idea is patentable if it is product or process. So let us see another kind of intellectual property called design. Design means shape, configuration, pattern, ornament, or composition of lines or color combination thereof applied to any article in the form of 2D, 3D, or both the forms. Bajaj iron box, new design. My comb is a new design. Can we put on my camera so that I can show some designs? Put on my camera. Are you able to see me? Dear coordinator, madam? So
No, sir.
So you can put on my camera so that I can show some example of the design. So Bajaj iron box is the design, flash design, brush design, mobile design, again car design. All these are different kind of design. You can see the pharma designs also I'm showing here. You see, are you able to see the slides, pharma designs?
Slide is visible, sir.
Okay. So the person who is host, they can put my camera on so you can see so that I can show the practical example also. See the capsule design. This you can see paranormal design, rounding design. So anything which looks beautiful, you can go for the designs. Curtain design, bedsheet design, textile, earrings, bangle, watches, all the designs are different. So any design, if you're able to go for the registration in the government of India. Okay. So see comb, wallet, Kolhapuri chappal, Adidas shoes, piva, fridge, fan, all the designs are different. You can see the bottle design. So anything which looks beautiful, that's an design. You know sharpener, but dual in nature. Pencil, pick up and paper. So all are new design. So let us see all the different designs. See, new design developed by another student while doing the project. You are also doing project, but you are going to the library, copying the senior thesis and just change the data. If I'm working on Rigacea tinctoria, same biochemical studies you are doing, same anti-inflammatory activity you are doing with the other medicinal plants. Do something new. Found something innovative. Try to bring compositions, process, products in the market. So if it is new, go for the patent. If design, go for the design. Let us see another kind of intellectual property called semiconductor integrated circuit. If physics, electrical electronics people are knowing what these circuits are. Earlier, we used to use China chips, Taiwan chips, then we used to. Now you can have your own, you can go for the registration. हो का हां मग काय म्हटलं मग बोललीस बोललीस का हां ठीक आहे मी पण लेक्चर झालं की बोलतो लेक्चर झालं की बोलतो मी बाहेर ठेव म्हटलं तर हम्म, हम्म, ठीक आहे मी सांगतो हो हो जस्ट अ मिनिट आय एम जस्ट टॉकिंग जस्ट अ मिनिट फॉर 1 मिनट वो सामान कुछ घर में रखे ना कुछ सामान उस 7वें फ्लोर के आगे कोई नहीं चढ़ता ना वो छुड़ियों पे रख दीजिए ना कुछ सामान ठीक है ओके 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 So, sorry for inconvenience. Let us see another kind of intellectual property called trademark or brand name. Tata, Bata, Parle-G, Good Day. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the good. Like I am selling Reddy's Laboratory is a trademark. Biocon of Bangalore, Shanta Biotech of Hyderabad. It's a name of the company. So you can get trademark for that. If you are developing your own startup, MSME company, keep the mark. R with round is a trademark. Ensel, you got the permission. TM means you applied for the mark, yet to get permission from the government of India. Duration is 10 years. You can renew every 10 years, subsidies like Tata, Bata, how long they're in the market. Let us see another kind of intellectual property called geographic indication. Bandar Laddu of Vijayawada. Famous. They got GI for that. Tirupati Laddu of got the GI. Rasgulla Bengaloria. Place name used to identify source of origin, quality, reputation, or other kinds of products like dazzling tea, Kanchipuram silk sari. Keep in mind that for the patent design trademark, anyone can file, but design for a GI group of people who involved in the particular business, they can, not individually. Magai Pan, Guntur Mirchi, they got GI for that. Your neighbor. So let us see another kind of intellectual property called copyright. Copyright is a bundle of right. It restricts unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, and software. The term is life of the author plus 60 years. Therefore, we get the protection for all the copyright work. No one can copy our movie, music. Bahubali is dubbed from Telugu to Hindi. Somebody has taken the permission, then copied. Then we cannot see it's dubbing or something, infringement of copyright. If they are not taking with permission, then you can see infringement of copyright. If you are writing books, novel, story, autobiography, or thesis, you can go for the literary work protection under section 2. If you are doing artistic work under section 2C, if you are doing dramatic work under section 2H, musical works 2P, sound recordings 2XX, cinematography films 2F. So each kind of work is getting registered in the Government of India. Term is life of the author plus 60 years. Let us see another kind of intellectual property called trade secret. Some invention, data, information, you are not getting protection in the Government of India. If you want to keep secret, you can. For example, recipe of benne dosa, recipe of some spices, or any chemical formula, any composition, if you want to keep secret. If you are using pizza in the Domino's, tasty and fluffy, you may take the homemade, it's not so tasty and fluffy. Coca-Cola, Maaza, Sprite, since how long you are drinking, but you don't know what is the formula of that or content of that. So again, trade secret. Even somebody developing new plant varieties like Jaya, Pusa, Padma, Basmati rice, food grain varieties. If they are new, you can go for the registration. Term is 15 years for annual crop, 18 years for the trees and vines. So we learned what is intellectual property, how to convert your research idea into invention, discovery is not patentable, and different kind of IPR. Now let us see how single product we can protect with the more than one IPR. You know this Apple laptop, this logo isn't trademark they got. Overall, they got design. Inside this circuit there, they got integrated circuit. The display between Nagpur to Guntur is output technology, and small booklet manual you can go for the copyright. Single product, but they got patent, design, trademark so that no one can copy. Samsung cannot copy. Vivo cannot copy. Oppo cannot copy. Only Apple is having all the right and they are in the market. They are earning like anything. That's again power of intellectual property. Can anyone tell me what in this small size, increase size, degrees, and this? What kind of IPR is? It's an design. Coca-Cola is a trademark. Inside the bottle, trade secret. The machine from which I'm making the bottle, technology, you can get the patent. The manual or website, you can get the copyright for that. So single product, they got patent, design, trademark, therefore no one can copy. So these are the different intellectual properties and we are getting protection for that. See, mobile again, you can check your mobiles. Somebody having Oppo, Samsung, Vivo, Apple, all the design is different. Megapixel camera is different. Instructions are different and they got patent for their technology and they got design registration also. Now, what are the career opportunities for students? If you want to come in the Government of India as an examiner of patent design, you should have qualification in MS chemistry, microbiology, physics, biotechnology, any branch of engineering also, depend upon the advertisement and vacancy. If you want to come as an examiner, trademark, GI corporation, law background. If you want to work in patent agent, any science grad, B Farm fellow is also eligible for that. BSc fellow is eligible for that, but two paper, one is objective, descriptive. If you qualify Viva, then if you are qualifying all, you are getting one number from the Government of India, you can become patent agent. If you are having knowledge of IPR, you can run the IPR cell, IPR policy of central government, state government, MNC company, university, even in NGO also you can work. There are many IPR firms in India, you can work with IPR firm also. Or many companies also having IPR, so you can work with them also. Now you learned everything. Now let us see how to file your application in the Government of India, where we can file. Any person, individual, startup, MSME, educated or uneducated, anyone can file the patent application. You can file offline or online. As you are from South, Chennai is your jurisdiction, you can file both. Documents require a covering letter indicating the list of document. Everything is available in the website. See the website. Form 1, Form 2 are required for that. Form 3 for foreign filing. Form 5 to add your friend's name. Form 18 for request for examination. If you are doing request, we examine your application. Fees is also given in the website. Please see the details fee schedule in the website. I'll give the website name www.ipindia.gov.in. Request for examination is Form 18. You are supposed to pay fees online or offline. It is left to you. It's for publication. If you want early publication, then only. Otherwise, no need to request. 18-month publication is available. If you want to get the patent within 1 year, you can file the expert examination as per Rule 24B. Then you can go for that. I'm in lecture. Will you call me at 3 o'clock. I'm in lecture now. Okay, you call me at 3 o'clock. So Form 18 is required, and PCT filing countries are supposed to file as an expert exemption, or you are alone or in group people, you are one of the ladies or government institute can also file. Fees is 8,000 individual, 60,000 for others, but you are getting patent within 1 year. This is a website. If you want to file patent, design, trademark, GI, you can know all this by clicking on. If you want to filing comprehensive e-filing column here, you can go with that. E-signature or digital required for that. Public search, mosquito repellent composition, mosquito catching device, fertilizer composition, you can search in public search or go to the Google patent, go to the EVSO patent, EPO or WIPO, get your work search whether new or not. If you're not only happy with this, then go to the paid database like PatSeer. Pay your fees, get your work search whether it's technology new or not, and go for the patent filing. So this is all about the intellectual property rights and their filing. With this, I put a full stop to my presentation. Any question will take for 5 minutes. Thank you. Please share the feedback link for all the students so that they'll get the certificate after 1 week.
Okay, sir. Students and faculty participants, if you have any doubt, please ask to our resource person, Dr. Bharat sir.
Good afternoon, sir.
Yes, ma'am.
Sir, actually, I have a doubt, sir. I heard any derivative of a molecule can be filed as a patent, sir.
If derivative is having any new use of that with a clinical application with other experiment, then you can claim a composition comprising that derivative with other experiment for treatment of so and so disease, then you can. Otherwise, no.
So that means after confirming of its pharmacological action only, we can able to file a patent.
Yeah, because
I mean, synthesis cannot be filed a patent.
process of synthesis also you can file, but your process should be new than the other process which are there in the public domain. Process of so and so purification or isolation, whatever you want to claim, you can claim for that.
Sir, that means I have an example, sir. Actually, aldol synthesis is used to get a functional group, sir. We'll change the derivative, but the synthesis process involves same mechanism. Derivatives, I mean, product will be different and ingredient, I mean, molecule will be different. Like that also can we go, sir?
If the process is same, then we cannot go for that. If you're getting product is different, what is that product? How it is different from that? And what is the clinical efficacy of that product? And claim not a new molecule claim. If it's not new, you can claim composition comprising that product with the other experiment for what you are using treatment of that. Okay?
Okay, okay, sir.
You give a title, composition comprising the whatever derivative with the expense what you are claiming for so and so treatment or for so and so this thing. Then you can claim as a composition, not a method of treatment.
Composition. Okay, sir. So it's the same process of application, no, sir? Whatever the thing is, only the title will be different and the drafting will be different, no, sir?
Yes, yes. But you are claiming product. Process is same. You can claim process, but you are not claiming the process. You are claiming only the product in the claim.
Thank you, sir.
Sir, is there any hands-on training session for the students or faculty members, sir?
You can call us at any institute. We can give the training. No problem at all. But at present in our office, we used to conduct earlier before Corona. Since Corona, we have been not started. We have returned to the government of India to give the permission, but still we not got. Once we get the permission, again we conduct here. But at present, every institute, those who are really involved in the research, they are calling us.
Yes, sir. Okay. Thank you, sir.
Any other question, please?
Sir, I have a question regarding filing of patent, sir. So actually, while uploading digital key, it is accepting only in the Internet Explorer with the old versions, sir. It is not getting updated to all browsers, sir. Any
Yeah,
update in that area, sir?
yes. You go to the IT team, there is a helpline further. You can call them, tell them. It's an IT department from Delhi. It's operating from Delhi. So
They'll
please,
support, sir.
numbers
Actually,
our email ID is also given. You can individually put all. I am being a professor, not expert in the field. I am not a patent agent. I am feeling so and so difficult. Please make me to understand how to use and all. You can. They will call. They will reply your mail or you telephone.
sorry, sir. Just actually, I thought of having a knowledge, sir. Thank you,
Website.
sir.
IT team's website is also given. Helpline numbers for digital signature also how to get also given.
Yes, sir. Class to digital signature.
Any other question?
Thank you, sir.
Okay, sir. Now it's for vote of thanks. It's time for vote of thanks. Very good afternoon, all of you. The main objective of today's webinar is a sound understanding on patent and design filing procedures for academic and research to safeguard their innovation and research outcomes for effective technology transfer. Hope this today's session successfully reached our objective. Thank you, sir. I would like to thank all the participants for being a part of this today's webinar on IPR, patent and design filing, organized by Vijaya Institute of Pharmaceutical Sciences for Women in collaboration with NIPAM Nagapur. So, my sincere gratitude to today's resource person Dr. Bharat N. Sauravamshi sir for sharing their valuable knowledge and information on patent filing and design filing. The session was more informative and enhanced our understanding on importance of intellectual properties in academic and research, sir. Thank you, sir, for accepting our invitation and given valuable session to our students and faculty members. My sincere thanks to NIPAM, Rajiv Gandhi Institute of National Institute of Intellectual Property Rights Management, Nagapur, for accepting our invitation and collaboration to organize this webinar on intellectual property rights. So, last but not least, I would like to thank our management and principal madam for constant support and encouragement to organize this webinar. So, I thanks to all the participants for your active participation and made this event grand success. Thank you all for constant support to organize this event.
Thank you, sir. Have a good day.
Thank you, sir.